Welcome to All Things Policy, a daily podcast supported by Pragati, a flagship media initiative of the Takshashila Institution. We're a bunch of policy nerds based in Bengaluru, and we like to bring a fresh perspective to Indian affairs and an Indian perspective to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to All Things Policy. I'm your host, Mihir Mahajan. Last week marked the 3-year anniversary of the controversial nullification of Article 370 and the conversion of the state of Jammu and Kashmir into two union territories. Article 370 was a temporary provision of the Indian Constitution that related to J&K. It was intended to serve as a stopgap pending resolution of various issues that pertain to the accession of the state to India. However, it endured nearly 70 years and served as a conduit through which the autonomy of the state eroded over time. Yet, Article 370 also enabled Jammu and Kashmir to remain one of the few states with a special status within the Indian Republic. Petitions challenging the constitutionality of the actions of August 2019 are still pending before the Supreme Court. The matter has not seen any substantial action, and the topic has vanished from our media. However, it has been more than 4 years since the last elected government of the state lost its majority. Jammu and Kashmir has been a centrally administered territory all this while without an elected government. A delimitation exercise has also been carried out, redrawing assembly constituencies in the state. The Armed Forces Special Powers Act has entered its third decade in Kashmir, and the Indian forces, paramilitary and paramilitary forces continue to have a large presence in the state to ensure peace. In this context, Hamīñ Ast is a book released last week by Manavi Books. Manavi Books is an open access digital book publisher that publishes digital books on contemporary matters of legal, social, and political significance, and the books that are written by experts for the general reader. Hamīñ Ast is authored by Arghya Sengupta, Jinaly Dani, James and Pranay Modi of the Vidhi Centre for Legal Policy. The book throws fresh light on the historical context in which Article 370 was introduced, the negotiations over its content, how it was used to bring Jammu and Kashmir closer to India, and finally, its nullification 3 years ago. I'm pleased to welcome Arghya Sengupta to discuss Article 370 from its origins to eventual nullification by parliamentary action. Welcome, Arghya.
Thank you, Mihir. Thank you for having me.
And many congratulations to you and your team on getting such a wonderfully well-written book out. And I want to start with asking you, what made you and your colleagues take up this project?
So, thanks very much, Mihir. I think that if I were to answer that question, I would have to go back to the 5th of August 2019, where I, like everybody else in this country, perhaps barring a few people, were watching astounded by what was happening in Parliament in terms of Article 370 being nullified. And I think as constitutional lawyers, we were particularly astounded because Article 370 was a provision of the Constitution that we all knew of, and we kind of knew of to be a permanent fixture in the constitutional scheme. But at the same time, is not an article that we read about or engaged with very often. Article 370 was a symbol of the special status of Jammu and Kashmir. And that's where we had left it. But on 5th August 2019, that symbol was no more. And that made us, as constitutional lawyers and researchers, think that let's dig a little bit deeper into Article 370. How did it come about? What was its journey over the course of the last 70 years? And how was this nullification, which some called abrogation, effectuated? Once we got into it, we realized that there is some academic documentation on it. There's a classic book written by A.G. Noorani on Article 370, which argues on why special status of Jammu and Kashmir was so critical. But apart from that, there was very little of substance that was written in terms of a book for a general reader. So once we got into it, we realized that, this is not just a legal essay or an article for a legal journal, but what we need to do is to bring Article 370 alive to the Indian citizen who wants to read more about this provision and why it mattered or didn't matter. So that's why we came to this conclusion that we're going to write a book. And as it says in its subtitle, it's a biography of Article 370. So it essentially talks about the life of this article from its journey through many contestations during its life and to its sudden and abrupt demise on the 5th and 6th of August 2019.
And I must say that it's a project that one must enter with trepidation, given both the historical context and the long journey that the article has had. And the book does a fantastic job of documenting it. So let me take you right back to the start, even before Article 370 existed. You write that for 500 princely states that acceded to India, and the instrument that was used was called an instrument of accession that was signed by the then Maharaja of Jammu and Kashmir, Maharaja Hari Singh. So can you first enlighten us what is an instrument of accession, and what did Maharaja do when he acceded to India via this instrument? What autonomy did he retain for Jammu and Kashmir, and what were the terms of the accession?
So the instrument of accession was a legal document that each of the 554 princely states that are today a part of India signed. Now, as you know, if you were to go back a little bit in history, India was a combination of British India as well as princely states. And princely states were these so-called autonomous units, but they were under the paramount see of the British crown. So they were under the overall protection of the British crown. They swore loyalty to the crown. But at the same time, they were autonomous, and the Maharajas and Maharanis retained their sovereignty. Now, all of them, when they became a part of India, first signed one instrument of accession, which said that they were going to be a part of India. Then there was, and I'm for the sake of simplification, saying a second instrument of accession, which is like a merger agreement. So that I am merging my territory into the territory of India that is going to get set up established on the 15th of August 1947. And then there was a proclamation that was publicly issued to this effect. So the combination of these three actions, an initial instrument saying I'm a part of India, a second instrument, there were some variations in this, but I'll leave that aside, a second instrument which merges the territory of the princely state into India, and a formal proclamation to this effect. The combined effect of all these three meant that the princely state ceased to exist, and what remained was that the princely state became a part of the Union of India. And 554 states, whether it be the states of Kuch Bihar, Mayurbhanj, Bhopal, all the states in Rajasthan, all of them entered into agreements of this kind with the Union of India. So it was two sovereigns, the sovereign Maharaja and the newly formed sovereign, which was going to be the Union of India. Now, in the case of Jammu and Kashmir, the distinction was that first, only the first instrument of accession was entered in. Maharaja Hari Singh entered into the instrument of accession saying that Jammu and Kashmir is going to be part of the territory of India, number one. This meant, and this was standard, this document was standard across all, there was no distinction per se with Jammu and Kashmir and the others, because what this document said is that it's going to be a part of India. Foreign affairs, defense and communications are three matters that the Union of India will deal with. In all other matters, and as for the residuary, the Maharaja of Jammu and Kashmir will remain sovereign. So everything except foreign affairs, defense and communications remains with the Maharaja. The interesting distinction, apart from the fact that this was the only instrument that was entered into and not the others right at the beginning, is that this instrument was not entered into before 15th of August 1947. In all the other cases, I mean, there's some controversy over Junagadh and Hyderabad, but let's leave that aside for a moment. All these other states, the princely states, had all become a part of India the time India became independent. But Maharaja Hari Singh signed this instrument of accession on the 26th and the 27th of October 1947. He did this at a time when there were armed militia from Pakistan who had entered and were capturing vast swathes of his territory. He was unable to defend the territory and needed help from the Union of India. If the Indian army had to come in, the Indian army had to know that it was not going to occupy somebody else's territory, but that it was coming in to protect its own sovereign territory. So on the night of the 26th, the instrument was signed, and the Indian army came in to Srinagar, airlifted into Srinagar on the 27th to protect what they now considered Indian territory. So this is how the instrument of accession came into being, and this is how it was different from the other princely states.
Thanks a lot. So a couple of points of clarification. You mentioned that the subjects of defense, foreign affairs and communications were ceded to the Union of India, while the Maharaja retained his autonomy on the other subjects. So clarification one was that only because only the first instrument was done? And in case of the other states, did the second instrument of accession essentially meant that they gave up autonomy on other subjects as well?
That is correct. It was only because the first instrument was signed. With the other states, with the second instrument, they became almost always they became like a regular state, which has part of the seventh schedule of the constitution. So they retain some subjects in the seventh schedule, others go to the union. So they become part of the regular machinery. Some become states in and of themselves, like Mysore became a state in and of itself. So it became, as the division of powers was as per the seventh schedule, where there were other very much smaller princely states like Mayurbhanj, which became a part of Orissa, or there were many princely states in Gujarat and Saurashtra, which became a part of Bombay state. So there were many arrangements, but broadly speaking, Foreign Affairs, Defense and Communications was the only subject ceded by the Maharaja of Jammu and Kashmir to the Union of India because he only signed that first instrument of accession at that point of time.
Great. And then there's the second point, which is made a lot of in the historical record, which is that in accepting the instrument of accession, Mountbatten mentioned something about the will of the people, and the whole setup was subject to the will of the people of the state. Can you throw a little bit of light on what that meant and why that it eventually proved to be problematic?
Yeah. So when Mountbatten receives this letter, and Mountbatten is then Governor General of independent India, we're talking about October 1947, there is obviously a war on, right? And so because there's a war on, it demands immediate acceptance of this letter. And at that point of time, Mountbatten writes, and this is again makes this acceptance almost like a conditional acceptance, that we accept. So now you're a part of India. But at the same time, the ultimate destiny of Jammu and Kashmir will be determined in accordance with the will of the people. This line is put in that acceptance letter. So that has been the genesis of the idea that the only way to conclusively determine the future of Jammu and Kashmir state is through a plebiscite. But having said that, Mountbatten also said that the will of the people can only be determined once her soil is cleared of the invader. And this is his words. These are his words, not mine. So once the soil is cleared of the invader means obviously that the Indian army is able to push the armed insurgents from the Pakistani side back into Pakistani territory. And then there is a plebiscite or whatever other way you want to determine the will of the people. Now, as we know, that never happened. Because on the 1st of January 1948, there was a ceasefire that was called under the auspices of the United Nations. And this is something that we go into in our book, as this was a matter, there was a grave disagreement between Jawaharlal Nehru and Sardar Patel. Sardar Patel did not want to go to the United Nations. Jawaharlal Nehru at that point of time, as a newly minted member of the international community, wanted India to have a certain moral high ground and took this matter to the United Nations. So as a result of taking this matter to the United Nations on the 1st of January 1948, a ceasefire was initiated, and that's the genesis of the line of control. So where the Indian army was on that day and where the armed militia coming from the Pakistani side were, that became the line of control. And the line of control was well within the boundary of the erstwhile Jammu and Kashmir state. So just if we were to get our geography right, so there were parts of Gilgit, Baltistan, parts of the Kashmir Valley, and the western parts of Jammu, all of which now fell within on the other side of the line of control, where the Indian army did not have territory. So the soil was never cleared of the invader in Mountbatten's terminology, as a result of which we had a little bit of a stalemate, that you have a situation where you promised that the future would be determined by the will of the people, but you can't hold a plebiscite because your soil is not cleared of the invader. So what do you do? And that's where Article 370 enters the scene.
So I think that's fascinating background there. So two observations. One is that what that meant really was that because the land of Jammu and Kashmir was never cleared of the invader, but there was a hope held out in the future. In 1948, it wouldn't have been obvious to people at that time that the plebiscite could never be held. In fact, there were several attempts, as your book documents, made by the United Nations. There were proposals of the different orders in which the Pakistani controlled militia, the militia on the Pakistani side would withdraw. Potentially, plebiscite could be held in various ways, but it didn't end up happening. As all of this is happening, the Indian Constitution is getting formed. There are debates, the work on the Indian constitution is ongoing. And obviously, before the constitution is accepted and India becomes a formal republic under its own constitution, the unsettled issue of Kashmir at this point needs to be somehow accommodated into the constitution. So I believe that's how there were initial kind of negotiations and a lot of back and forth between the Kashmiri leadership, both in the form of the Maharaja and then later the Yuvraj, and also in the form of Sheikh Abdullah and his interim government, took place on an article for the constitution that would code in Jammu and Kashmir as a part of India. And that became Article 370. So very briefly, could you just tell us about the negotiations that took place, and then how did, even prior to January 1950, how did this article end up becoming a part of the constitution that was eventually ratified?
Yeah, this is a very fascinating period in the history of both constitution drafting and Jammu and Kashmir. And we were surprised that not very much was written on it. And there's a reason why that's the case. As we write in our book, Article 370 was an afterthought. When the draft constitution was presented before the Constituent Assembly, there was no mention of Jammu and Kashmir. There was no Article 370. And there is a reason for that. The reason for that is that at that point of time, India's concerns were in terms of the international ramifications of the issue. This issue had already been internationalized. We were heavily on the back foot in the United Nations. We had seriously misjudged the impartiality of the United Nations. And there was an external battle to be fought. At the same time, internally, within Jammu and Kashmir, no one was really talking about its relationship with India, because at that point of time, the major rift in Jammu and Kashmir was between the Maharaja and Sheikh Abdullah. And the Maharaja, Hari Singh, had been, because of difficulties that he had historically with Sheikh Abdullah, had been asked gently but firmly, together with the Maharani, had been asked to leave the state. And even Sardar Patel, who was his biggest source of support in Delhi, asked him to leave and hand over his reins to the Prince Regent, Karan Singh, who became the de facto Maharaja of the state, though he reigned as the Yuvraj. So at that point of time, Sheikh Abdullah, and I think we must remember this, Sheikh Abdullah's entire movement of the National Conference was against the Dogra Maharaj. And there were two things, as in it's often seen as in a very reductionist way, as this was a Muslim state with a Hindu subject, with a Hindu ruler. And that might be the case. But one of the key fault lines was the fact that the Dogras were from Jammu and Sheikh Abdullah was a Kashmiri. And we access some fascinating documents from the Ministry of Defense, which have just said that this Jammu and Kashmir state was a historical accident, because there are essentially territories which have absolutely nothing to do with each other. There is Jammu, which is largely Punjabi, Hindu, with a certain population of Muslims who are very different from the Muslims in the Kashmir Valley, who are dominant with a small population of Kashmiri Pandits. And then you have the territory of Kargil, which is against Shia Muslims, mostly dominated by Shia Muslims. And then you have Ladakh, largely Tibetan influence, together with Gilgit-Baltistan on the other side of the line of control. So very, very diverse state. And so Sheikh Abdullah's battle was really about Kashmir as opposed to these other elements of the state. And so his one-point agenda at that point of time primarily was, how can I depose the Maharaja? So this is what was taking up most of the time and energy, not just of folks in Jammu and Srinagar, but also New Delhi, because they were fighting a battle in New York in the United Nations, but also looking to resolve this internecine conflict between the Maharaja and the Dogras and the National Conference. So in this, we realized in about May of 1949 that there is no provision, and the Indian Constitution is almost ready to go, but we have no provision. And at that point of time, a decision was taken, and it was primarily engineered by N. Gopalaswamy Iyengar, who had earlier been a Diwan of Jammu and Kashmir and was then a member of the drafting committee, later transport minister, and a very close confidant of Jawaharlal Nehru on Kashmir matters at that point of time. And he put out a draft, and the draft was a bit of a placeholder to say that till broadly Jammu and Kashmir and the Union of India can agree as to what, and I'm summarizing here, as to what the substantive nature of this relationship will be, we have this placeholder which says that Jammu and Kashmir is a part of India, and it kind of replicates that instrument of accession. Foreign affairs, defense, communications is with India. The rest of it continues to remain with Jammu and Kashmir unless Jammu and Kashmir itself gives it to the Union of India. Broadly, that was broadly the scheme that came about. And with some iterations here and there were lots of minor controversies that I won't get into. between May of 1949 and October 1949 when it got presented for the first time before the Constituent Assembly. But I'll leave it by saying that there was really not much debate about Article 370 in the Constituent Assembly. There was really not that much thinking about Article 370. It was meant to be a placeholder. No one thought it was important. And this is not something that we write in the book. This is the book, as you mentioned, is a co-authored book. But this is my personal view, is that at that point of time, I think putting in an article of this sort was a historical mistake. And we need to think about how things could have been done different.
It's a fascinating kind of introduction to how this article came to be. And you called it a placeholder, and yet it survived 70 years. Let's take a quick break at this point, and on the other side, I'll ask you a bit more about the actual text of the article itself and what it encodes. Welcome back. We are chatting with Arghya Sengupta about his co-authored book on Article 370, a biography of Article 370. So, Arghya, on the other side, we were talking about how Article 370 was a placeholder that essentially encoded some aspects of the instrument of accession, and essentially presumed that the question around the plebiscite, the question around determining the will of the people, and what aspects of Indian law and constitution would apply to J&K would be solved in relatively near future. Yet it ended up lasting 70 years. Ahead of this conversation, I went back and read the text, and surprisingly to some, because it's been subject of so much scholarship and so much political controversy over the years, the entire article is less than 500 words and has just 3 clauses. Yet you call it in your book one of the most, or in some of the material around the book, one of the most complex provisions in the Constitution of India. So one is, how does such a short article codify the special status of Jammu and Kashmir via having included the requirements of consultation in some aspects and concurrence in some aspects of the Jammu and Kashmir government when laws made by the Indian Parliament were to be made applicable to the state?
Yeah, so first of all, Mihir, on an aside, short articles can be hugely complex. So, for example, the due process clause in the United States Constitution, as in, is essentially 2 words, due process. I mean, the words that matter are 2 words. But that has spawned about 300 years of legal contestation that, as we've seen in the recent abortion case, still continues. So I think that length has very little to do with complexity. But having said that, the reason Article 370 is complex is because of the fact that the drafters were trying to write something without saying anything, right? So I know this may sound a bit complicated itself, but the purpose was that let's try and keep this article as hollow as possible, as devoid of content as possible. And what do I mean by content? By content, I mean what is the substantive nature of the relationship between Jammu and Kashmir and India? Can, for example, the Supreme Court of India's jurisdiction extend to Jammu and Kashmir? Will Jammu and Kashmir be able to fly its own flag, or will it have to fly the flag of India? These are difficult questions, and these are questions that were top of mind for people at that point of time. In fact, Sardar Patel didn't like the provision because it didn't make the Supreme Court's jurisdiction automatically apply to Jammu and Kashmir. Fundamental rights of citizens would apply differently in the rest of India and in Jammu and Kashmir. Now, these were all very, very difficult questions. Now, Article 370 did not answer those questions because there had been no discussion whatsoever between the 2 parties in terms of answering those questions. So what did Article 370 do? Article 370 essentially laid down a procedural mechanism, right? It basically, if you see it as it's an article, broadly speaking, in 3 parts. As far as the first part is concerned, it's saying that, replicating the instrument of accession, that the power of Parliament to make laws for the state of Jammu and Kashmir is limited to foreign affairs, defense, and communications. And if that law is actually dealing with foreign affairs, defense, and communications or not will be determined by the Parliament in consultation with the Jammu and Kashmir legislature. Second, if in any other matter, if Parliament wants to make law, it can only do it with the concurrence. That is, only if the Jammu and Kashmir state government says yes. That's the first part. And the Jammu and Kashmir state government is clarified as meaning, for the purposes then, the figurehead, that is at that point of time, later it became the governor, but at that point of time it was the Maharaja, who would act on the aid and advice of Sheikh Abdullah who by that time had been appointed the Prime Minister of the state of Jammu and Kashmir. This is again a hat tip to how it was different. Jammu and Kashmir had a Prime Minister and not a Chief Minister. So that's the first part of the article. The second part of the article is that the Constitution itself, the provisions of the Constitution, again, will apply to Jammu and Kashmir only as per an order made by the President. And that order made by the President, if it is in relation to foreign affairs, defense and communications, will be with the consultation of the state. And if it is on any other matter, will be with the concurrence of the state. Okay, and I think that's the second part. The third part, I think, which is also important, is that two things apply automatically. First, Article 1 of the Constitution, that Jammu and Kashmir is a part of India. That applies automatically. So there's no doubt left about that. And number two, Article 370 itself applies automatically. So those are the two things that are provided. And the last bit, which actually has become relevant, is how do you make changes to Article 370? How does it go? So the framers thought about it, which is why the point comes that it's a placeholder. And they say that notwithstanding anything that we have written earlier, the president, that is the president of India, can say that the article ceases to be operative, okay, or operates with some exceptions from any date, provided that he has a recommendation from the Jammu and Kashmir Constituent Assembly. So there is a mechanism for its own demise that is presaged in Article 370, that it can be an order by the President of India on the recommendation of the Constituent Assembly of Jammu and Kashmir, which at that time in 1950 was not yet set up, but was going to be set up to frame a constitution for Jammu and Kashmir. That, as we know, became the source of Article 370's demise in August 2009.
So thank you for that loyally yet very understandable introduction or explanation of the article. What I took away from that is that to the extent that the Maharaja had ceded his autonomy and allowed India to make laws related to the three matters, defense, foreign affairs, and communications, the powers of the state government, in a sense, were limited to being consulted when such laws were being made. And on all the other matters, as the instrument had not conceded those matters to the Union of India, the powers were much higher because their concurrence was required before making the laws applicable. Now, there is a very important distinction that I think came out in what you said, as well as became very, very important in 2019, is Constituent Assembly is a special term. It's not, and it's something that becomes very important. So what I want you to maybe explain to us is what exactly is a Constituent Assembly, and why does the definition, and what is its definition? What is its purpose of existence?
Yeah, so this is a very good question, because the Constituent Assembly in political theory is an expression of the constituent power of the people. Now, what does that mean? That means that the people are coming together you can deem it a legal fiction, for the first time to come together to give themselves a constitution. Okay. And under that constitution, parliaments will make laws, and that is seen as an exercise of constituted power. So first the people come together and constitute themselves, and that is done through a Constituent Assembly. Once that Constituent Assembly is there and ready, parliaments or legislative assemblies that are creatures of that constitution then exercise constituted power. So in political theory, this is the difference between a Constituent Assembly and a parliament or a legislative assembly. And that is why in Article 370, both the Constituent Assembly as well as the J&K government are separately referred to. So it is said that if you want to do away with the article, then you have to have a recommendation from the Constituent Assembly. Because it is envisaged that the Constituent Assembly will draft a constitution for Jammu and Kashmir. Some of these difficult questions about flag, Supreme Court, etc., will be answered. And once it is answered, they will make a recommendation to the president that, delete this article now, no need for a placeholder anymore. Or whatever, keep some part of it if it's necessary. And in other places where you're talking about day-to-day matters of, does this refer to foreign affairs, defense and communications, you take the concurrence or the consultation, consult with the J&K state government. But there is a provision there also, is that if you have taken this concurrence before the time the Constituent Assembly has been set up, then the Constituent Assembly's concurrence is also needed. Okay, so just to complete the picture there. But this is theoretically the difference between the Constituent Assembly, that is the people of Jammu and Kashmir, as core as it can get, as representative as it can get, vis-a-vis the legislature.
I think that's fascinating. So historically, if I look at it, this is what happened. The instrument of accession was signed. The voice of the will of the people couldn't be judged at that point in time for various reasons, as we spoke about. And the Indian constitution essentially accommodated this uncertainty around Jammu and Kashmir's laws by Article 370. And then in 1951, the Constituent Assembly, I believe, of Jammu and Kashmir gets formed. They do a bunch of deliberations. By 1957, they have set up a constitution for the state. Now, this is something that the book goes into a little bit, but I had a question here about what exactly did the Constituent Assembly of Jammu and Kashmir do, and to what extent their lawmaking and constitution needed any kind of correspondence or concurrence from the Indian government at that time.
Yeah. So I think that's a very good question. We didn't go into it in the book because of the fact that this book would become too lawyerly, and we really wanted to keep this book accessible for a general reader. But this is an invitation from you to be lawyerly, so I can't resist. But just a matter of history before I get into it. Before the Constitution of India came about, there was supposed to actually be two constitutions. There was supposed to be a union constitution and there was supposed to be a provincial constitution. The union constitution would give the powers of the union and the provincial constitution would give the power for the provinces. And to add some further complexity, several princely states, which were neither part of the union at that time nor part of any provinces of British India, were drafting their own constitution. So Saurashtra was drafting its own constitution, Mysore was drafting its own constitution, Travancore was drafting its own constitution. And in fact, some group, there was a very interesting document that I read during our research called the Constitution of the United States of Rajasthan, okay, which was all the princely states of Rajasthan came together and were drafting a constitution. So one is that this had some precedent that there were going to be several constitutions. Of course, they never came about. But in the case of Jammu and Kashmir, because also a historical reference had been made to the will of the people in accepting the instrument of accession, in a constitutional setup, the will of the people can be determined through a constituent assembly. So it was decided. By the time Article 370 had been drafted, it was envisaged, and by 1951, it became a matter of concrete reality that a constitution would be set up. And a constitution would be made for Jammu and Kashmir. Now, the Jammu and Kashmir constitution, if you look at that document, is essentially a mirror image of the Indian constitution, broadly speaking. It sets up, because the Indian constitution does not automatically apply to it. So it kind of sets up its own provisions on how judges are going to be appointed, how governor is going to be appointed, but the provisions are in substance the same. There are some optical differences. So if you're going to be appointed as a judge of the High Court in Jammu and Kashmir, then you take your oath of allegiance to swear allegiance not to the Constitution of India, but to the Constitution of Jammu and Kashmir. Okay, so there are some very significant but optical differences of this kind. So Jammu and Kashmir Constituent Assembly, as it starts its work in 1951, but it's kind of rendered redundant because of the political dissension that happens in 1952, where Sheikh Abdullah and Jawaharlal Nehru have a falling out. Delhi appoints Bakshi Ghulam Muhammad to take over. And that is seen as the beginning of a series of puppet regimes that have been appointed in Jammu and Kashmir. So the Jammu and Kashmir Constituent Assembly kind of quietly does its work, does a very decent job, and there's a decent burial that is given to it. So largely, it's a document that is very similar to the Indian Constitution. It also makes it clear that Jammu and Kashmir will be inalienably a part of India. So which is seen as a kind of reference to how the will of the people is being manifested.
So essentially, by 1957, two things have happened. The Constituent Assembly of Jammu and Kashmir has been formed. It has written a constitution that, as you say, largely mirrors or uses Indian constitution. And then in 1957, the Constituent Assembly of Jammu and Kashmir is dissolved. And that means that it does not exist anymore. And that kind of brings to mind a question, is when a Constituent Assembly is dissolved, and some people have said whether it was dissolved or not is unclear and so on. But is there, and I asked this question because that became important in 2019, as we'll see. But is there a way to bring back a dissolved Constituent Assembly if there were unresolved questions within the state?
Now, this is a very philosophically interesting question, because the question of how a Constituent Assembly is dissolved will go back to how a Constituent Assembly is formed. And how is a Constituent Assembly formed? It's not formed under a constitution. It usually is formed by the people, usually say in a revolution or in some kind of extra constitutional action where the people decide that this is what I'm going to do. So this is what happens after the French Revolution. The French Revolution deposes the monarch, and then there is a void. And then the people decide that, okay, as in we are going to have this set of people who will govern us, as in read by Robespierre, and that, of course, becomes a reign of terror. But that's essentially an extra constitutional political act that has political legitimacy and not legal legitimacy. People accept it. Okay. Now, are we in a situation where people accept that there is going to be a group of people in Jammu and Kashmir who will stand up and say, I am the real representatives? Not at all. Okay. So I don't think that there is a possibility that either you can argue that the Constituent Assembly was not dissolved properly. It was absolutely dissolved properly as per the law. And whether a new Constituent Assembly can come up is a hypothetical question, which does not seem like a political reality at this point of time. But I must say this, that there was a very important legal act between the Constituent Assembly forming and dissolving, which had nothing to do with the Jammu and Kashmir Constitution, which was a presidential order issued under Article 370 in 1954. Now, as I told you earlier, the president could issue orders making parts of the constitution that didn't relate to foreign affairs, defense, and communication to apply to the state of Jammu and Kashmir, provided the Jammu and Kashmir government said yes. Now, the Jammu and Kashmir government said yes, and large swathes of the Constitution of India was made to apply to Jammu and Kashmir, okay, through this presidential order of 1950. And that was the beginning of a trend of presidential orders, which have meant that when it was nullified on 5th of August 2019, there were actually 93 out of the 97 to 99 provisions in the Indian Constitution on which Parliament can make laws. It could make laws for Jammu and Kashmir. 260 or so articles of the Constitution, most of the key ones applied to Jammu and Kashmir. So, as had been said, as in it had been attributed to Nehru, ki ghiste ghis jayega. So, it was a bit like it got eroded over and over and over and over. And so it got so kind of extinguished over time. But the presidential order was also important in another respect, is that it brought in Article 35A. And Article 35A of the Constitution has been seen as a bit of a sore, and certainly has been constantly in manifestos of the Bharatiya Janata Party have been mentioned. So as far as their political promise is concerned, their political promise has been fulfilled to the T. Because Article 35A essentially continued this so-called special status in practice. So 370 was like the symbol of special status, and 35A was the special status in practice, which reserved jobs for permanent residents of the state, which allowed only permanent residents of the state to own land. So these were seen as special status on the ground. And so that and fundamental rights of the Constitution did not apply equally to the state of Jammu and Kashmir as it did to the rest of the country. So I think that was a very important step that had been taken in 1954, where large parts of the Constitution of India was made to apply even before the Jammu and Kashmir Constituent Assembly finished its work. And it could only do it because the Jammu and Kashmir government said yes, that you have our consent.
So fascinatingly, what had happened then by 1957 is the Constituent Assembly of Jammu and Kashmir had dissolved itself, yet Article 370 remained in the Indian Constitution, and it had a provision that said that it can be removed only with the consent or with active recommendation, if I'm correct, recommendation of the Jammu and Kashmir Constituent Assembly. So it sounds like the intent of the provision was that we are putting in a placeholder. The Jammu and Kashmir Constituent Assembly will form and will do its thing, and then will provide a recommendation to the Union of India, essentially recommending, now that we have done our job, we can now get rid of Article 370 because the terms of a relationship between India and Jammu and Kashmir and the will of the people has been determined. Yet the Constituent Assembly disappeared and the clause remained in Article 370, which is what I think, going back to the beginning of the conversation, you said that many in the legal fraternity then started seeing Article 370 as more or less permanent because the mechanism of its removal was taken away. So let's take a quick break at this. Yeah. So let's take a quick break at this point, because we have reached a logical point where the Constitution of India in large swathes is applicable to the state. The state has formed its constitution and gotten rid of its Constituent Assembly. And over time, between 1957 and until 2019, large chunks of laws made by the Indian Parliament continued to become applicable to Jammu and Kashmir with the concurrence. So taking a break, on the other side, we'll come back and talk about the actual nullification of Article 370 and how that was carried out, and what your book talks about in that regard. Welcome back. So, as Orgo was mentioning on the other side of the conversation, removal of Kashmir's special status, that was parts of it were encoded in Article 35 in 35A and was made possible via the existence of Article 370. It was a long-standing kind of demand. If I were to quickly refer back to your book, there was a party in Jammu called the Praja Parishad, which had essentially said that they wanted or was in favor of full accession to India with all of the Indian constitution and laws becoming applicable. The Shama Prasad Mukherjee had agitated and even gone to Kashmir and unfortunately passed away in Kashmir's jails for some of these demands. And it became a part of the manifesto of the Bharatiya Jansangh and then eventually of the Bharatiya Janata Party, its later incarnation. And it was a poll promise. And in August 2019, essentially, the government introduced a series of measures in parliament that were passed with a significant majority that essentially nullified Article 370. So in that history, I think the first part I want to ask you about is that it was thought by the legal fraternity to be more or less permanent, even though it actually in the title itself says temporary provision and you have called it a placeholder. How did the article act as a source of its own nullification?
Yeah, so as I mentioned, Mihir, the article always envisaged that it could be nullified, right? So there was a provision there which said that the president could nullify it, abrogate it, or make it cease to be operative, provided it received a recommendation from the Constituent Assembly of Jammu. I think there are two things to note is that is why we constantly use the word nullify as opposed to abrogate, because it's not that 370 is gone. They have put in a provision in place of 370 as it existed, what I read out, which says basically that the Indian constitution applies in toto, okay, to Jammu and Kashmir. No exceptions, no modifications, it applies. So that is what Article 370 says today. In my view, and before I come to how this was achieved, in my view, this is what should have happened in 1956, when the Constituent Assembly of Jammu and Kashmir finished its work. That the Indian constitution applies, and whatever exceptions that you may have, you pass a law and you say by law we actually agree that these are the exceptions. So then it becomes clear that everyone is on the same page. The asymmetry is provided for under a law that you have now entered, that Jammu and Kashmir has passed. Okay. I think this is what should have happened in 1956 and we missed that opportunity. So what happens in August 2019? So when we say nullification, there are three legal actions that have taken place on the 5th and 6th of August 2019. And I think it's important to disaggregate them. Because I think there is a general sense that, in this country that either you can be for the government or against the government. So you have to say everything in their favor or everything against them. And I think this matter is a matter that I've been trying to say in this course of this discussion as well as in the book, that the matter is complex. We have to move beyond simple binaries of right, wrong, constitutional, unconstitutional. We have to understand it in its historical context before we can come to our own assessment of whether this was the thing to do or not. Three actions were taken. First, there is no Constituent Assembly of Jammu and Kashmir. So who makes this recommendation to the president? They use Article 367, which is an article for interpretation of the constitution. This article had been used previously. Earlier, there was a Sadar-e Riyasa that was the de facto governor in Jammu and Kashmir, and they used that to say that actually that means governor, if I remember this correctly. So they used the same article to say that Constituent Assembly means Legislative Assembly of Jammu and Kashmir. Now, subject to that theoretical objection of constituent power and constituted power, which has some merit, this is a commonsensical change. If there's a principle in constitutional law that a provision of law cannot create a redundancy. There is no Constituent Assembly. So how does this provision operate? You would say that, okay, doctrine of necessity, Legislative Assembly. So that's what they do. Number one, there may be problems with it, but that's the first step. The second step, once you've said it's the Legislative Assembly, now there is no Legislative Assembly in the state because the state is under President's rule. Given that the state is under President's rule, that recommendation is made by Parliament. Now, Parliament makes the recommendation to the President that Article 370 be nullified and this provision that it applies in toto be brought in. And then number three, the President nullifies on the basis of that recommendation. So there were three distinct legal steps that were taken at that point of time on the 5th and 6th of August, which resulted in this.
I think just stepping back for a moment, I think it's important to recognize here, and your book refers to this two hands need to clap aspect of Article 370's provision. Essentially, the clause 3 that said that recommendation could come from the Constituent Assembly of Jammu and Kashmir to modify or make the provisions of Article 370 no longer relevant had to come from the Jammu and Kashmir Constituent Assembly. And as you identified now, that was made that was interpreted as the Legislative Assembly in 2019. The key factor here, though, was that unlike before 2018, when there were regularly, or at least at some points in time, there were democratically elected governments within the state. In 2018, for example, Chief Minister Mehbooba Mufti's government was in power with support from the BJP, which kind of withdrew the support for various reasons in 2018. And then governor's rule was followed by president's rule. And so as of August 2019, we had this situation where the elected government of Jammu and Kashmir was no longer in place. The Legislative Assembly had been dissolved and president's rule had been enforced. So there were no elected people's representatives in the Legislative Assembly to make a decision to recommend, if we go with that definition that the Constituent Assembly equals the Legislative Assembly, then if a Legislative Assembly had been in place, the Assembly would have had to make that recommendation to the President. But instead, what happened is the representative under President's rule, the representative appointed by the President, who was at that point, if I understand right, the governor of the state, made that recommendation. So in that sense, the two hands that clapped, instead of being a Legislative Assembly directly of Jammu and Kashmir of elected representatives, and on the other side, being the Union of India represented to the President, were actually essentially the President's representative making a recommendation to the President. And the book goes into a bit of detail on that. So can you just maybe talk about this circumstance and what does it really mean?
Yeah, I think, Mihir, you summarized it beautifully. There's very little more that I have to add, but on the 5th and 6th of August 2019, it did seem like the President clapped his own hand. Okay, because on the one hand, he was the President of India, and on the other hand, it was his delegate, as in who was governing in Jammu and Kashmir. Okay, at that point of time, the Parliament had to make that recommendation, so the Parliament made that recommendation. But the Parliament was his delegate, as was the governor. So the fact is that he clapped his own hand, and there's no two ways about that. Okay, it's a factual matter. Now, legally speaking, and I'll be very clear in saying this question can arguably go either way. Because if you were to take a very literal interpretation of the Constitution and bring in the doctrine of necessity, this was perhaps, and whoever has drafted this provision has done a remarkably clever job of drafting. Okay, and this maybe can be argued both ways as far as the letter of the Constitution is concerned. But the spirit of the provision, and this is what I've been trying to say, is that the spirit of the provision is that any decision on the future of Jammu and Kashmir state will be taken jointly by the state as well as the union. Now, one could argue that this spirit had been made a mockery of from 1952, the day that Sheikh Abdullah was deposed and Bakshi Ghulam Muhammad was put in what became the chief minister, at that time prime minister. One could argue that a succession of puppet regimes meant that really there was no consent of the people at all. So, if there was what is this fiction that we are trying to carry on? And that might be an argument that's worth considering. But the point is that the Indian government, whether it should have or shouldn't have, is a different issue. My sense is perhaps at that point of time, again, we could have just accepted that instrument of accession, but it said that the will of the people would be ascertained in some shape or form. It was a promise that was made. And I think given that that's the promise that was made, it seems that while Article 370 had really run its course, and it was sort of its death was imminent at some point of time, it would happen because no one liked it. As in, we launched this book last week in Delhi, and Wajahat Habibullah, who was a serving bureaucrat in Jammu and Kashmir, said that even the separatists didn't like it. No one liked the provision. It was nobody's child. Because the fact is that it didn't allow for full integration, it didn't allow for separation, it had become kind of nobody's child, a very unloved article. So the purpose of the book is to essentially say that we need to understand this article holistically, even when we are understanding it as a question of constitutional law, which it ultimately will be because the matter is in the Supreme Court, it has not been heard yet. It has to be understood in this context. And it can go both ways. in terms of how it will be interpreted. And that's why I think this provision is so complex. It is complex because it's not just another provision of the Constitution. It's an agreement, like a treaty that was entered into by India and at that time the sovereign state of Jammu and Kashmir, which was the instrument of accession, which was manifested in this article. And given that it was treaty-like in its formulation, it's a provision that is kind of distinct and has its own character.
I think that's a beautiful way of putting it. And one of the kind of key things you pointed out over the course of the conversation is that the progression or the erosion of the autonomy in some sense, even though the instrument of accession limited it to 3 subject areas, large swathes of the Indian constitution and law became applicable. The head of state changed from the Maharaja to the Sadr Riyasat to the governor. A large, even decent provisions like the goods and services tax or reservations for the economically weaker sections were easily made applicable in Jammu and Kashmir with the concurrence of its government. The kind of one aspect that kind of still sticks out, and maybe it's worth considering, is throughout this whole exercise, and depending on political viewpoint, one can determine whether a particular regime or consider whether a particular regime is puppet regime or elected regime and what kind of legitimacy it has. But for a large part of this period, there was some level of democracy or elections to Legislative Assembly in Jammu and Kashmir. Those elected representatives were voting, maybe under pressure from Delhi at various points or under other considerations. But throughout this period of erosion, there was the spirit of that concurrence of the Jammu and Kashmir Legislative Assembly was seems to have been largely kind of followed, whether that assembly was there. Well, is there any kind of precedence about, and in your research, in the course of from 1952 till 2019, of Indian laws being made applicable at Jammu and Kashmir during a president's rule kind of situation? That's kind of part one. And part two is all of these, while eroding, still kind of remained that slight thread of Article 370 that maintained that concurrence requirement continued to remain, but that final thread was cut in 2019. So how do you kind of see the erosion in one part, and then the second part is the actual cutting of the cord, if you will?
Yeah, I would actually put it a little differently. I would actually think that thread was not cut, but perhaps the bond was forcibly made more solid. Like it was knotted very tightly in 2019. So I think maybe a slightly different analogy there. And in answer to your first question, I mean, we must be very candid that several elections to the Legislative Assembly of Jammu and Kashmir were rigged. Okay, and we must be extremely frank about this. It is not as if there was real autonomy for the people of Jammu and Kashmir. Elected legislators were often decried by citizens. It's not as if some of the points that the Bharatiya Janata Party makes about how unpopular leaders are in the valley are partly true. And that's what we found in all our historical material, that there is a lot of angst against local Kashmiri leaders that exists at that point of time in the valley. But having said all that, you're right in that for what it's worth, a fiction was maintained that the people of Jammu and Kashmir were consenting to this action. But if you were to argue the other side, as you were doing, is that it was a fiction, and it was kind of a fiction that had become so perverse that it was perhaps time to do away with it. So my personal view is that this is something that was going to happen because it was an article that had run its course. But you wish, and this is maybe me being idealistic, that you wish it happened in a way that the people also wanted it to happen. And as Wajahat Habibullah said at our launch, that you never know, maybe people would have wanted it to happen because no one really liked this. People liked Article 35A a lot, which is why there's a demand now in the Union territories of Ladakh and Jammu and Kashmir to bring back 35A in some shape or form. So my sense is that this was a odious history. When we looked at the book, as in the history of Article 370 was an odious history. So there were many reasons for wanting to bring that to an end. But do the ends justify the means? I leave it for the readers to decide.
Fascinating. That brings me to my final question. And I know your book ends in 2019 after the nullification, the so-called nullification. And yet you have an epilogue that mentions that petitions are pending for the Supreme Court to decide on the constitutionality of the action. And also, while the petitions are pending over the last 3 years, we have seen several things happen with respect to the state, whether it's the internet suspensions that were there for more than a year, or whether there are media restrictions that a lot of people are pointing out are unique to Jammu and Kashmir, or at least are not present in the rest of India. The fact that delimitation exercise has been carried out and constituencies are being redistricted, or whatever the right word is. So it seems like time is moving ahead. And from 2019 to today, we have seen a lot of things happen within the state, as one would expect. And yet the petitions remain in the Supreme Court. So I guess two parts. One, you have already answered, that there are arguments both ways, and the courts could look at arguments and look at this holistically in some manner. But there's also ways of looking at it from a pure constitutional perspective, and there could be different answers. So one is what do you think about this 3-year kind of state where the status quo on the ground is changing every day as events take place, and the court hasn't yet heard the matter? What do you expect in terms of the court to do, in terms of, not the action itself, but both in terms of what is it the responsibility in some ways to hear the petition expeditiously before more and more changes happen within the state or within India itself as a whole? Or is it that the court can actually further wait it out and hope that this works, and that the legitimacy is provided by situation on the ground?
See, I think this is an unpardonable delay by the Supreme Court, but not surprising. The fact is that the Supreme Court has said whenever this matter came up that we can put the clock back. But realistically, are we going to put the clock back? I don't know the answer to this question, but I can only give another example. There is another petition pending in the Supreme Court about the constitutionality of the division of Andhra Pradesh into Andhra Pradesh and Telangana, which happened in 2011 or 12, maybe 2013. I'm sorry, I don't remember these. Is the Supreme Court really going to turn the clock back on the formation of Telangana? I think we all have the answer to that. So my point is that this is unpardonability. And decide whichever way you want. And there are strong arguments on either side to be made, but decide the matter. For God's sake, hear the matter. I mean, this is the job of every institution in the country, that they must do their own job. And I think the Supreme Court is primarily set up by the Constitution as a court which is going to hear matters of constitutional importance. And this is as significant a matter of constitutional importance as we have seen in this country. And my sense is that the court, it's incumbent upon the court. And I hope that we have a new Chief Justice taking oath later this month. And I hope that the Chief Justice will take up this and other matters of constitutional importance that remain languishing.
On that note, I extend my thanks and congratulations again to you and the entire team.
But I'm sorry, if I may add one last thing, there is one benefit to the court not having heard the matter, is that it has allowed us to have a title to our book, which is called Hamīñ Ast, which, as everybody will know, is taken from famous Persian couplet, Gar Firdaus bar ruye zameen ast, Hamīñ Ast, Hamīñ Ast, Hamīñ Ast. So that if there is paradise on earth, it is here, it is here, it is here. So we ask the question of Article 370, is it here? And that's only been possible because the Supreme Court has not heard this matter.
Well, there's always something positive one can find, and I'm glad that an extensively researched book that attempted to tackle this question intellectually from a constitutional law angle as well as from the historical context has been made available. It's and just to remind our listeners, the book is a free ebook available through the Navi Books website. Go ahead and and access it. It's fascinatingly written. It's very lucid and easy to read, and free of legal jargon, yet retains the quality of argument that one would expect and that one hopes courts will engage with. Meanwhile, we also hope that the Jammu and Kashmir, which remains special in some ways in terms of still facing continuing militancy, in terms of presence of the military to keep peace, and the restrictions on media, and in some sense internet suspensions that keep its population deprived of certain fundamental rights to some extent, is also able to move past, and the integration subject to the will of its people is complete in the same way on the ground that it has in some sense been completed in the Constitution after the nullification action. So on that note, again, let me thank Arghya for his time and for enlightening us on this very important topic. And thank you very much.
Thank you, Mihir. Lovely to be here.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.